Welcome to Middle Class Matters. Today, 18th June 2023. Let's business news in English from Dr. CMA MV Allegation. We will see the report of the expert committee constituted by the Honorable Supreme Court of India on the Adani issue. The committee's recommendations. Para 85. For ease of reference, the provisions of Section 12A of the SEBI Act are extracted below. 12A. No person shall directly or indirectly A. Use or employ in connection with the issue, purchase or sale of any securities listed or proposed to be listed on a recognized stock exchange, any manipulative or deceptive device or contrivance in contravention of the provisions of this Act or the rules or regulations made thereunder. B. Employ any device, scheme or artifice to defraud in connection with issue or dealing in securities which are listed or proposed to be listed on a recognized stock exchange. C. Engage in any act, practice, course of business which operates or would operate as fraud or deceit upon any person in connection with the issue dealing in securities which are listed or proposed to be listed on a recognized stock exchange in contravention of the provisions of this Act or the rules or the regulations made thereunder. D. Engage in insider trading. E. Deal in securities while in possession of material or non-public information or communicate such material or non-public information to any other person in a manner which is in contravention of the provisions of this Act or the rules or the regulations made thereunder. F. Acquire control of any company or securities more than the percentage of equity share capital of a company whose securities are listed or proposed to be listed on a recognized stock exchange in contravention of the regulations made under this Act. Para 86. As seen above, the approach adopted by SEBI has been to explicitly stipulate with a deferred prospective effect from April 1, 2022 that transactions involving a subsidiary of a listed company would be deemed to be a transaction with the listed entity. Likewise, SEBI has explicitly stipulated with effect from April 1, 2023 that transactions with an unrelated third party would be regarded as a transaction with a related party if the purpose and intent of the transaction is to benefit a related party. The provision of a deferred prospective effect has enabled listed entities to rearrange their affairs in a manner that is not violative of the law. Such a glide path is a matter of good practice in economic legislation, where disruptive changes do not hurt the ease of appreciating what is expected of members of society to be compliant and to ensure compliance. Para 87. Having adapted the path of making explicit stipulations prospectively, the path of testing the principles underlying the regulations governing related party transactions has been abandoned. That being so, it would be legally infeasible to attack past transactions on the standards that have later been made applicable with prospective effect. Para 88. The committee does not intend to criticize SEBI for having adapted the approach of explicitly stipulating requirements with prospective effect in preference to the approach of testing the existing law on a principles-based approach. Such an adaptation of a choice is SEBI's prerogative in its legislative capacity and an expression of its best judgment of what is appropriate policy, so long as there is nothing unreasonable or subversive in choosing one path over the other. There is no scope for an adverse comment on the approach or to arrive at a finding of a regulatory failure. Para 89. However, the committee believes that once an approach is adapted, it must be implemented and adhered to in accordance with the law. Predictability and certainty are vital elements of regulation, since a majority of society would desire to be compliant and therefore would wish to know what it ought to do to remain compliant. If past transactions were compliant with the law as was applicable when they were transacted, and more so if changes have been made subsequently to outlaw a repetition of such past practices, it would follow that there can neither be a repetition of the same structures in future, nor can there be an attack on the validity of past transactions. Para 90. As regards the principles of introducing long business association as rendering a business counterparty to be a related party, some caution would be in order. Certainty and consistency in serving a business relationship is a virtue, and unless there is a strong benefit associated with burdening an arm's length business relationship as being a related party transaction for no reason other than having been a long-standing relationship, the measure may lead to an imbalance between the cost of the measure and the benefits from the measure. If the terms of contract with such a party were to be forced by law to be made public, it would impose a burden on such a counterparty that his competitors would not face. The appropriateness of such an approach is an important dimension and must be handled with great care. Para 91. SEBI has submitted that long association has been the basis of impacting the independence of an independent director, with the law imposing a term limit and the basis of auditor rotation, term limit on serving as statutory auditor. The role of independent director is one of overseeing governance, while the role of an auditor is one of being a check and balance and auditing compliance. Such relationships have an element of fiduciary accountability, and a prolonged association could erode the independence and fairness expected from a person playing that role. Para 92. SEBI has also repeatedly submitted to the committee that the transactions may be technically compliant with the letter of the law, and it may be difficult to prove a violation in a court of law, but the spirit and purpose of the law must have been violated. At this stage, the committee does not desire to express any view on merits, since its remit is not to conduct a parallel probe and express an opinion on individual transactions, particularly when SEBI is expressing a desire for more time to investigate and return findings more firm than prima facie findings. Para 93. However, the remit of the committee clearly is to examine if there is any regulatory failure in the wake of the allegations made. Towards this end, purely for purposes of a flavor of the facts on hand, the detailed presentations made by SEBI in respect of each of the 12 suspicious transactions are annexed in the compilation of submissions. Para 94. A few big picture facts that are ex facie evident are worth spelling out with specific regard to the regulatory framework governing related party transactions. A. The allegation of non-disclosure is not sustainable, since by the application of the legal definition of related party, none of the counterparties were related parties in the eyes of the law at the time of the transactions. B. SEBI's pursuit of investigations is based on the premise that it is pursuing the spirit of law, which flies in the teeth of the prospective amendments with deferred effect that SEBI has made on the legislative side. C. Some transactions relate to the period of nearly a decade ago, which predate the LODR regulations, when the listing agreement was the instrument of law that was applicable. D. Several transactions are evidently transactions with parties that do not fit the definition of related party, but other transactions between such unrelated parties and related parties have led to the allegation of the spirit being violated. And E. Some transactions or transactions between the subsidiary of the listed entity and the related party, which SEBI has brought under coverage of the law governing related party transactions only with effect from April 1, 2022, and that too with deferred prospective effect. Para 95. The committee notes that predictability of the law is an important touchstone for economic legislation. SEBI has been actively learning from developments in the market and has consistently been reacting to such learning by regular amendments to the regulatory framework. Para 96. A key question that would then emerge is whether a commercial business can be accused of violating the law when the law at the relevant time did not exist, or did exist but in a manner and form materially different from how it is formulated later. Para 97. Therefore, arguably, when the LODR regulations make a reference to the listed entity, it could be argued that such a reference included in its sweep an inclusion of its subsidiaries. A person alleging a violation could argue that what is prohibited from being done or is regulated in how it can be done cannot be effected indirectly through a subsidiary without being hit by the prohibition of the legislation or regulation. Para 98. However, in the eyes of the law, the picture completely changes when the regulations are positively amended with specific regard to preventing the possibility of such an interpretation. Even amendments to the law could be of two types: clarificatory amendments and substantive amendments. It is strict law that substantive amendments can take prospective effect, while clarificatory amendments would clarify the existing provisions and therefore would relate to how the regulations must be interpreted. Para 99. In the instance case, on November 21, 2021, the LRDO regulations were amended for the sixth time that year, and that too with their two deferred effective dates of April 1, 2022 and April 1, 2023, to expand the scope of related party transactions. A contravention or a device would have to be proven that a transaction purporting to be a transaction with an unrelated party is actually a related party transaction, masquerading as a normal transaction. But such a framework would take effect from April 1, 2022, and therefore transactions prior to such date cannot be accused of being violative. Para 100. Since the amendments were not only given prospective deferred effect, but also were given an effective date that would start with the next financial year, it is evident that the legislative intervention was a substantive one, taking care to provide listed entities with time to rearrange their affairs to remain compliant. Therefore, it would not be legally tenable to assail transactions that were evidently affected when the newly envisaged substantive law does not exist, on the premise that they violated the law. 101. SEBI is still investigating the matter and is examining old transactions to arrive at a view on whether there was any fraud in the underlying facts and their depiction. The committee is therefore anxious not to comment on the merits of any fact under investigation and has therefore restricted itself to the law and its application. Para 102. The committee is equally cognizant of the fact that the allegations in the Hindenburg report are substantially based on publicly available information. However, the manner in which it has been extrapolated the information and presented it has led to a serious nosedive in the prices of Adani stocks. The prices have undergone a correction and have improved, but not to the level as existing prior to January 24, 2023, the date of publication of the Hindenburg report. Para 103. This points to a simple thesis. The market has factored in the seriousness of the allegations on the commercial facts of the transactions in question. Regardless of whether the law is violated, the market has decided to reprice the Adani stocks. There has been an infliction of a price erosion and a subsequent mitigation. Every action that is legally compliant need not be an action that is considered desirable. If the market feels the actions taken in the past were not entirely desirable, it would reprice the stocks, but that by no means can be extrapolated to inexorably conclude that a violation of law has been made out in the facts of the case. Please like the video, give your comments, subscribe to the channel. Thanks for watching.